This week, the SEC filed an appeal notice with the Second Circuit Court. This moved the Ripple v. CC case forward. Still, people in the XRP community don't know what the SEC wants because it has to file a Form C first. According to the most current report, Ripple will be appealing the court's decision on how to handle the $125 million fine. In the notice of the SEC appeal that was made earlier this week, the securities regulator set August 7th as the date of final judgment. However, they did not say which grounds they plan to challenge, so people in the XR community are still not sure if the SEC will challenge the programmatic sales ruling from July 2023 or the $125 million fine that Ripple has to pay for institutional sales on August 7th. But according to a statement, the SEC plaintiff has contested the final court decision from August 7th about Ripple's $125 million fine. However, the securities regulator wasn't happy with the court's ruling in Ripple vs. SEC, so the blockchain company took the money. This happened because the government was putting pressure on Ripple to pay a $2 billion fine before the decision was made. Fox Business reporter Eleanor Turret said earlier today that the regulator in the Ripple vs. SEC case has not yet filed its Form C with the Second Circuit. This would give the court more information about the appeal. She said that the agency needs to speed up this process so that they can give Ripple clear directions on how to move forward. In addition, Ripple has 14 days from today to file a cross-appeal in the XRP lawsuit if it wants to. Some Bitcoin lawyers have been thinking about when the case against Ripple might be over. Attorney Fred Rispoli, who is in favor of XRP, says that the Second Circuit Court probably won't make a ruling until early 26. He did say, though, that the appeal could be thrown out at any time if both sides could agree on an answer. There was a lot of selling pressure on XRP after the SEC's appeal, and the price dropped by more than 15%. The market value of XRP is $29.7 billion at the time of this writing. Since the SEC recently decided to fight a court decision about the initial coin offering act, Brad Garlinghouse, CEO of Ripple Lab, said that the company will keep going to court against the SEC. Our Garlinghouse made the following statement at Impost on October 2nd. It was also posted on ease. They lost in every important way. He made it clear that XRP is no longer seen as a protection, despite its appeal. Judge Alyssa Torres of the New York District Court said in July of last year that when XRP is sold on public platforms, it is not a security. However, the court said that selling XRP to institutional buyers had to follow security rules. As a result, Ripple was given a $125 million fine. Even with this small win, Garlinghouse, the CEO of Ripple, has promised to fight the SEC over the XRP decision. The SEC will put it off now that everyone agrees this is fine, so it's time to make an appeal of the decision. Stuart Alderode, Ripple's chief legal officer, said in a statement that he didn't agree with the assistant's choice and that it was foolish and wrong. He also said that Ripple is thinking about making a cross-appeal. In July of last year, Judge Alyssa Torres said that XRP sold on open cryptocurrency markets was not a security. The SEC has now filed an appeal against this decision. In the court case between the SEC and Ripple, this is a new development. The SEC's appeal move got a lot of attention at first in the Ripple world, and Ripple QA Garlinghouse talked about his thoughts on the matter. Brad Garlinghouse said that the SEC still doesn't know that they lost and Ripple came out on top. He also said that he would fight the agency in court until the end. In their case against Ripple, the Securities and Exchange Commission did not protect investors in any way, according to Victorious, the well-known CEO. Instead, what they did hurt DSX's credibility and image. Garlinghouse also said that XRP's legal situation would not change despite the annoying and false worries, and he said this after saying that XRP is already recognized as an asset that is not a bond under the law that is already in place. People like Jenner and the CC would have backed out of this situation a long time ago if they were smart. The cryptocurrency business, the Securities and Exchange Commission, and the rule of law have already won out over these unfounded and overblown fears. Let's be clear, XRP is officially recognized by the law as a non-security asset, and this will not change soon. We will fight in court as long as it takes. As you may remember, the Securities and Exchange Commission made it clear in their failed interlock appeal that they had no plans to challenge the fact that XRP is not a security. On Wednesday, the U.S. Securities and Exchange Commission said it would be appealing a court ruling that limited its power to oversee Bitcoin exchanges. A decision from July 2023 will be looked over by the Securities and Exchange Commission, which plans to ask the Second U.S. Circuit Court of Appeals in Manhattan to do so. According to the decision made by U.S. District Judge Alyssa Torres, the XRP coin that Ripple Labs sold on public exchanges does not meet the legal criteria of a security. This means that the sales of XRP, which were worth about $757 million, did not have to follow the rules that protect investors set by the Securities and Exchange Commission. If the appellate court decides to uphold this decision or read securities laws in a restrictive way, it could make it harder for the Securities and Exchange Commission to regulate commoner platforms like Coinbase and other companies that trade new, non-traditional financial items. Judge Torres also sided with the Securities and Exchange Commission, saying that in August, sales of an extra $728 million worth of XRP to investors should have been in line with the rules set by the SEC. Ripple was given a $125 million fine, but this fine has been put on hold until the review process is over. The stay will stay in place until the ruling from the Second Circuit Court of Appeals comes in. This is true even though the SEC had originally asked for a $2 billion fine. The Securities and Exchange Commission's decision to appeal was seen by Ripple CEO Brad Garlinghouse as stupid and frustrating, though he did say that it wasn't expected. "We will keep fighting in court until we win." Even so, the company can still appeal any part of Torres's decisions that Ripple thinks are unfair. Let's say that Garlinghouse said in a statement that they will fight the Securities and Exchange Commission in court for as long as it takes, since XRP is now legally not a security. The present court case between Ripple Labs and the SEC is affected by this announcement. The Securities and Exchange Commission has decided to appeal the court's decision from the previous year that said XRP coins sold on secondary markets were not securities. This comes after the United States District Court for the Southern District of New York made a decision in July 2023 that was seen as a big win for Ripple and the cryptocurrency industry as a whole. The SEC sent in the results of a study that was put together by an appeal. The appeal could make people doubtful about XRP's regulatory standing again, which would hurt the price of the cryptocurrency and investors' trust in it. In December 2020, the Securities and Exchange Commission complained to Ripple Labs that it had sold XRP coins in a way that wasn't authorized by the SEC. The main point of the lawsuits has been to find out if XRP, Ripple's own cryptocurrency, is considered a security under U.S. law. The July 2023 verdict said that XRP sold on secondary markets like exchanges did not meet the legal standards to be considered securities. This meant that Ripple's direct sales of XRP to institutional investors would be considered to violate securities laws. In some ways, this was a win for Ripple. The decision was seen as a big win for Ripple and set a big example for other cryptocurrencies that are now being looked into by U.S. regulators. The fact that the Securities and Exchange Commission wants to review the 2023 decision shows that the agency is still not ready to give up on its fight over how to classify XRP.